It is particularly essential for businesses expanding interstate or internationally, as it forms a basis for foreign registrations under treaties like the Madrid Protocol. And in our increasingly digital economy, federal trademarks are indispensable for safeguarding intellectual property against counterfeiting, cyber squatting, and global competition, ultimately preserving economic value and mitigating litigation risks. If all goes well, it takes approximately a year to get a mark registered. However, the priority date, as I mentioned before, is the date that the application is filed. After the review process, which takes about 7 to 9 months, if the examiner approves it, the mark is published for opposition in an official publication open to the public to review. There's a 30-day publication period. If no one opposes registration of the mark, then it will officially register about 6 weeks after that. So that gets us to about a year.
What can and can't be patented? Well, you can patent articles of manufacture. For example, a new design of an adjustable wrench. You can patent a machine. For example, a new equipment for manufacturing a composite baseball bat. You can patent a method. For example, a new process of purifying water. You can patent a system. For example, everybody has a smartphone, so a new application software for your smartphone you get a patent on. You can patent a composition. For example, a new pharmaceutical compound. What you can't patent are abstract ideas without any practical application. For example, a mathematical formula like E equals MC squared. You cannot patent laws of nature. For example, gravity. You cannot patent naturally occurring substances, for example, oil.
There are two laws that I also want to mention that protect intellectual property in a more legal way than contractual or registration or anything like that. One of them is the works made for hire term. What this means is that if a creator is an employee and creates a work within the scope of their employment, or if the creator is an independent contractor and that work falls into a specific category under a written agreement, the hiring entity is considered the author and initial copyright owner of that work rather than the actual creator. Another is if a trade secret is stolen, you can sue under state law or the Federal Defend Trade Secrets Act. But the key here is still prevention. Once information becomes public, you cannot put that genie back in the bottle.